With same-sex marriage and no-fault divorce being threatened, it's important to understand what you can do to legally protect your relationship without getting married. The first and easiest thing you can do is update the beneficiary on all of your accounts, retirement accounts, savings accounts, everything. You probably get emails and reminders to update your beneficiaries. Do not ignore them. This designates who gets your account when you pass. Next, you'll want to establish what's called a durable power of attorney. This is a legal document that gives your partner the authority to make financial decisions on your behalf if you are alive but unable to do so. They can do things like pay bills, manage finances, pay taxes. The third thing is to get an advance directive, sometimes referred to as a healthcare directive or a living will. This states your preferred medical treatment in the case that you are incapacitated. This helps alleviate the burden that your partner may feel in making decisions for you medically because you've already laid out exactly what you want. This includes things like how long you want to be on life support, comfort care preferences, and preferences around organ donation. If there's ever conflict between medical opinion and the wishes of the family, this advance directive will act as the source of truth. Depending on your state, the advance directive might include assigning a medical power of attorney, which is different than your financial power of attorney. This gives your partner the authority to make medical decisions for you in the case that you are incapacitated, although they are legally bound to first honor the advance directive that you set in place. These documents are also important for allowing unmarried partners to visit you in the hospital, so if that's something you're worried about, this is what you can do. The last two things you can do is set up a will and a living trust. These two things will be bypassed by your beneficiary designation. However, it's still important to have these for all of those other things that aren't included in your beneficiary designations. For example, if you want to make sure that they get all of your belongings when you pass, you would need to set up a will. A trust, on the other hand, is an entity that holds your assets and then transfers them to a successor once you pass. Beneficiaries and trusts will bypass the probate process, and these are important to have even if you are married. Probate is a legal process that validates a will after someone passes away, and if decisions have to go through probate, it is very time consuming and can cost you a lot of money even if you're married. Both a will and a trust can be set up with an estate attorney. Me and Logan are currently in the process of setting up a trust, a financial power of attorney, and medical power of attorney for each other. If you don't do these things, all of your assets will essentially go to next of kin. These conversations can feel uncomfortable and scary, but facing them now is so important so your partner doesn't feel powerless and confused and overwhelmed and shut out in the case that you pass.